Hi, Professor. So my state for my project was Connecticut. Just real quick, the prime difference between Texas and Connecticut is that Connecticut features an appointive system, which means that unlike Texas, Connecticut judges and prosecutors are appointed by a judicial selection commission. So in Texas, as you know, prosecutors and judges are elected. So in Connecticut, a person who wishes to be a judge or a prosecutor has to apply to this commission, and that commission judges that candidate based on merit. And then if they deem them kind of worthy of filling, like for instance, like a vacancy on a particular bench, they nominate that candidate to the governor, and the governor selects a candidate, and then the state legislature confirms them. So that's how you're put into office as either a prosecutor or a judge. Okay, so structure and purpose. So I kind of split up. So the court system of Connecticut is split into 4 tiers of courts, as represented right here. I'm going to just go in order of echelon. So the top tier is Supreme Court. It's composed of a Chief Justice and 6 Associate Justices. It's also called the Court of Last Resort. And like I said before, all judges are appointed. So even the Supreme Court justices are appointed by governors and confirmed by legislature. So the second tier is the appellate court right here. It's composed. The appellate court tier has 9 judges and 1 chief judge. But each case, 3 judges here decide each case. Similar to the Supreme Court, they can hear cases en bloc, and they do not hear witness testimonies, or they don't even talk to witnesses, and they base their decisions on court records, briefs, and oral arguments. So as we learn in class, like Texas appellate courts, they pretty much just go over what happened in the original trial. So the third tier is Superior Court. So Superior Court is divided into 4 levels. So the first one being criminal, second civil, third family, fourth housing. So I'm going to go over each one. The first level, criminal, it's adversarial like in Texas, and they hear felonies, misdemeanors, violations, and infractions. The civil level is obviously they hear civil matters, so like monetary disputes, stuff like that. And civil matters are presided over by a jury or a judge, depending on the preference of the parties and the nature of the claim. And then there's the family level. They hear family disputes, and then the housing level, they hear housing complaints. And this Superior Court level is the largest level of the state's 4-tier structure, just a huge caseload, obviously, because of these 4 levels. They have general jurisdiction for the trials of offenses. And there's probate level. They hear, adoptions, estates, minors, and unlike these courts, probate judges are actually elected. That was kind of interesting to me. They serve 4-year terms. And also this diagram kind of does a good job representing how the appeals work in the state of Connecticut. So you got the Superior Court right here. I don't know if you could read it from there. And it's the court of general jurisdiction in most cases, except for probate. They originate in the Superior Court. And from the Superior Court, you can have a direct appeal straight to the state Supreme Court. And yep. So I'm going to go on to the primary differences between Texas and Connecticut that interested me. So actually, I'm going to start with the criminal process. So criminal process, you have the arraignment, which is when the bail is set, the attorneys are appointed, or if you get one appointed to you, you're appointed at this stage, and you have beginning of discovery. So it's when prosecutors when prosecutors begin disclosing stuff to the defense, and the defense start conversing with their client. Another thing that's kind of interesting in Connecticut, they have these things called diversionary programs, which if depending on mitigating and aggravating circumstances, if you're like a first-time offender, the judge may offer you this, which can potentially dismiss your charges. So get it off your record, pretty good. After the arraignment, you have pretrial process. That's 3 to 8 months, with trials being held every 4 to 6 weeks. And failure to appear to these trials may result in your bail being revoked, and you can be charged with failure to appear. Then after that, you have the judicial pretrial. That's when your attorneys, so this is just another stage before trial, trying to see if you can resolve the matter before trial is deemed necessary. So during this stage, the attorneys and judge meet, and it's, again, like I said, the last resort before trial. And if this is not resolved, the defendant is placed on what's called a firm jury list, which means that they are on a 24 hours notice for trial. So they can get called up anytime. Finally, you got trial. So like Texas trial, there's some similarities and differences in Connecticut's trial process. So first you have voir dire, jury selection, and then you have presentation of evidence. You have then the state calls first witness and begins to introduce evidence. Then you got defense cross-examinations and they can challenge evidence at this part. And then the defense calls witnesses, they rest. And then finally you have the state closing argument, defending closing argument, and then another state closing argument. What's interesting about this is more like in Connecticut criminal trial process, there's no opening arguments. You just jump straight into presentation of evidence, which is interesting. And then another thing that kind of stood out to me is that during jury deliberation for criminal trials, the jury has access to all types of evidence they want. So I mean, they can bring in any types of evidence, any direct quotes. Whereas in Texas, the jury are pretty isolated. They don't get to re-see evidence. And also in the state of Connecticut, if no unanimous verdict is reached, you have the judge declares a mistrial. Whereas in Texas, the judge can tell the jury to go back and figure it out. So just as a concluding slide, Texas versus Connecticut differences, which interested me. First of all, Texas has elected judges and prosecutors, whereas Connecticut has appointed judges and prosecutors, like I said in the first slide. Texas criminal trials have opening arguments, whereas Connecticut criminal trials lack opening arguments. You just jump right into the presentation of evidence. Texas juries may not access pieces of evidence during deliberation. Connecticut juries have access to all articles of evidence. In Connecticut, if unanimous verdict is not reached, the judge orders a mistrial, whereas in Texas, the judge can tell the jury to go back and figure it out if they can. And another thing that interested me is, in my paper, you'll see in the history section, Connecticut has some roots in the colonial area. It goes back to the 1600s, whereas obviously in Texas, we haven't been in a state for that long. So that concludes my presentation. Thanks for watching.